Good day, Crime Talk aficionados. It is the weekend update of Crime Talk. All of the top stories located in one convenient video. I hope you enjoy it. Have a wonderful day. We'll see you next time on Crime Talk. So lately I've been trying to cut back on my Red Bull intake because I feel like lately it's been a little more difficult to fall asleep. And if you've been a fan for a while, you know that I also don't drink coffee. So I've been trying these little bottles of Magic Mind. So if you're like me and you don't like the crashes and jitters that come from coffee and Red Bull, then you have to try out my new favorite caffeine hack, Magic Mind. I love that they are small and easy to transport. I usually drink them on the way to work in the morning, and by the time I'm at my desk, I am ready to take on whatever craziness the world is going to throw at me. Magic Mind also has ashwagandha in it, which works to decrease stress, which certainly I can use a little of. And I'm looking into stock in the fridge here with Magic Mind so that my whole team can feel the benefits. So they gave me a great discount code. All you have to do is go to magicmind.co and use the code CT40, that's short for Crime Talk 40, for 40% off your first subscription. Or if you aren't into that, you can get 20% off your first purchase. I'll leave the notes in the show link. And the best part is that they have a money back guarantee because you know it's always about the money. Go to www.magicmind.co/Crime Talk discount code CT40.
The Daybell case. The case is not stayed in regards to the Daybell matter. What does that mean? Well, let's take a look at the order that the judge filed. It was made available to the public as of today. On October 13th, 2022, during a motions hearing held in this case, the state made an oral motion for the court to enter a stay in this case pending the determination of the competency to stand trial in the co-defendant's case. Obviously, the co-defendant is Lori Vallow. Obviously, Daybell and Lori's cases are currently joined for the purposes of trial, and the defendant objected to the state's motion to stay the case. He then states, for the reasons stated on the record, the court denied the motion to stay. So what does that mean? As of now, the case in the speedy trial clock is ticking. Now, granted, the 6-month speedy trial has been waived, and Daybell has indicated he would do whatever he needs to do to continue the jury trial. Why is the judge not staying the case? Well, the argument from the prosecution has been, first, the cases were brought in the same indictment. We only want to do one trial, and that one trial is expensive, but two would be really expensive. Judge Boyce, to his credit, has not stayed Daybell's case as of yet. Does not appear he wants to wait and see what is going on with Lori Vallow. Why? Because he can't. When a case is stayed and there's one defendant and competency issues arise, it's a no-brainer. The case stops, other than the restoration and status updates with the court. What do you do when there are multiple defendants? Well, you can't just hold them in custody until the co-defendant gets better. What if the day does not come? What if it's years down the road? What if the co-defendant does not get better, can't wait for the perfect results, and in the process, you potentially violate the defendant's right for a speedy trial? Now, take the money aspect out of the picture that the prosecution keeps raising. They're starting to act like they're scared to go to trial. I'll say it again. A prosecutor that feels good about their case says, Judge, you tell me where and you tell me what time, and I will have my witnesses and my evidence ready to go to prove this case beyond a reasonable doubt. Let me know in the comments if you, or maybe like me, not getting a warm, fuzzy feeling that the prosecutor wants to keep going forward.
Newly released surveillance video shows Gabby Petito walking around a Whole Foods supermarket with her would-be killer, Brian Laundrie, just hours before he strangled her and dumped her body in the woods. Now, the video shows the couple walking an aisle in the Jackson, Wyoming supermarket on August 27th, 2021, the day Miss Gabby Petito was last seen alive. It picks up shortly after a couple left the Mary Piglet's Tex-Mex restaurant nearby following a public argument between Laundrie and 3 female staffers, which Petito ultimately apologized for. They could be seen parking Petito's white Ford Transit van in the parking lot around 2:11 p.m., sitting in the car for a minute, and then Laundrie gets out of the driver's side and slams the door. He then approaches the rear of the van, grabs a baseball cap from the back compartment. At this point, Petito steps into view from around the passenger side, apparently still upset at Laundrie over the scene that he caused at the restaurant earlier, as she still has her arms crossed in front of her. Now, Laundrie has his hands in his pocket with his face hidden under the hat and obscured behind sunglasses. Now, footage from inside the supermarket shows the couple walking the aisle as they made their way through the store for about 15 minutes. Petito could be seen grabbing some items as she wandered the store and putting them into a white duffel bag. Once their shopping is complete, about 40 minutes later, the couple could be seen returning to their van and heading onto Highway 89, which leads directly to the Bridger-Teton National Forest campsite, where Gabby Petito's remains would be found 3 weeks later. It truly reminds us of how quickly life can change. Pick your friends very carefully. Pick your future lovers, spouses, girlfriends, boyfriends, whatever, very carefully. If they've got anger issues, be concerned. Verdicts have been reached in the trial of Paul Flores and his father, Ruben Flores, in connection with the 1996 disappearance and presumed death of California Polytechnical University student Kristin Smart. A jury in Monterey County Superior Court in California found Paul Flores guilty of murder. The defendants' trials were simultaneously held, but they were both given a separate jury. In the Ruben Flores case, the jury found him not guilty. Now, Paul Flores faces 25 years to life in prison. Now, both father and son were arrested back in 2021 after investigators searched Ruben Flores' home multiple times. Investigators said Paul Flores killed Smart at the college before hiding her body under Ruben's shed. Now, Smart's remains have never been found, and Ruben was arrested at his Arroyo Grande residence on a charge of accessory after the fact, which is obviously a felony. Now, prosecutors allege that Smart's body was once buried under the elder Flores' deck, but her remains were recently moved. According to court documents, authorities are in possession of alleged biological evidence that makes them believe that the victim was buried underneath Ruben Flores' deck at one time. Now, as you may recall, Smart disappeared on May 24th, 1996, after attending an off-campus party near Cal Poly. She called her parents that night around 8 p.m. and left a voicemail. It was the last time that their parents heard from their daughter. Now, Paul Flores told investigators that he accompanied Smart back to the dorm after the party where she lived. He said he then left and walked to his own dorm room at the Santa Lucia Hall. Now, Flores had a black eye while speaking to investigators at the time. He explained that it happened after playing basketball, but authorities were skeptical of his story. Flores later changed his story and claimed he got the black eye while working on a truck. Eventually, Flores stopped talking to investigators and obtained an attorney. When investigators brought cadaver dogs to the campus, the dogs reportedly made their way to room number 128 at the Santa Lucia dorm where Flores lived. 2 dogs showed interest in the mattress on the left-hand side of the room, according to court records, which was Flores' side of the room. Now, according to the dog handler, there was a strong possibility that a deceased body had been in that room. Not exactly the hardest science in the world, but hey. So not exactly the best evidence in the world, and obviously a body was never obtained. But hey, that's the way it goes. A jury has spoken. We'll see if legal errors were made on appeal, because there will be an appeal. Next, the government responds to Alex Murdaugh's motions. As you may recall, Alex Murdaugh, he's been charged with the 2 counts of homicide, specifically murder, and 2 counts of possession of a weapon during the commission of a violent crime in connection with the June 7th, 2021 shooting of his wife, Maggie Murdaugh, and their son, Paul Murdaugh. They were killed at the family's Mosul estate, a little hunting lodge that they called it, 1,700 acres, because, everybody has one of those. Some of the motions filed by the defense the other day, and we talked about them in our video over the last couple of days. Well, the government has responded, specifically when they addressed the motions filed by the defense that alleging that the Curtis Eddie Smith had failed a polygraph examination administered by law enforcement agencies probing regarding the murders of Murdaugh's wife and younger son. And according to Mr. Murdaugh's attorneys, Smith's response to questions about his knowledge and potential involvement in the double homicide indicated deception. Law enforcement's confirmed this account, which obviously makes it some big news. Now, the prosecution responded as saying basically the motion was completely inflammatory, arguing that Mr. Murdaugh's motion was clearly just trying to prejudice the reader with a recounting of inadmissible polygraphs and salacious scuttlebutt that is offensive to the memory of his victims. Specifically, the prosecutor noted in regards to the polygraph examination itself, in addition to discussing the inadmissibility of the exam, Waters claimed that the attorneys for Mr. Murdaugh misled how the polygraph works and tried to clear that up, stating that the polygraph machine is not a lie detector, nor does the operator who interprets the graphs detect lies. Rather, the machine records physical responses from which an examiner may draw somewhat subjective inferences about whether the examinee is being deceptive or otherwise motivated by a sense of guilt or some other emotion. The prosecution disputed the inference made by Mr. Murdaugh's legal team that a visible spike in a photo taken from the exam was indicative of a deceptive response. It appears, according to the prosecution, that Murdaugh's experienced team of defense lawyers do not understand how polygraphs work, or they are vastly overstating their point to this court and for the public consumption. Those are the only two choices, according to the prosecutor. And even if the polygraph did mean what Mr. Murdaugh tries to mislead the reader into believing, nothing about that would exclude Mr. Murdaugh as the perpetrator of the crime. The prosecutor, like all good prosecutors, then notes, the overwhelming weight of the evidence to be put forth at trial will show the defendant, Alec Murdaugh, murdered his wife and son with malice aforethought. Now, addressing the latter assertions, the prosecutor noted in the state's response, the defense incorrectly asserts the state has not provided any information about the time of the murders. As you may recall, Murdaugh attorney said, hey, we need to know exactly what time this occurred because otherwise we just can't provide an alibi, because, there's, 24 hours in a day. Where were you all day long? You got to know these things. And so the prosecutor responded, quote, this is not true, he wrote. The fact that Maggie and Paul were killed at Mosul on June 7, 2021 might be one of the most well-known facts in the state. If the defense needs further help for a start time, there is evidence of which the defense is well aware, showing Murdaugh's presence along with the victim at the crime scene at 8:44 p.m. Bam! Ooh, what a response. So it looks like the defense motion to try and create some doubt, at least in the court of public opinion, may not be getting the bang for their buck, that's for sure. Now, that motion did not elaborate as to what evidence may have been established as to this start time, but there has been some information, some reports that there was perhaps a video or some type of audio recording as well. So I don't know. It's going to be an interesting case. I know some people aren't excited about it, but I'm telling you, I think it's going to be big, huge. Continue to follow it. Next on the docket, the nonsense of Darrel Brooks' trial is hopefully coming to an end. After the state rested its case on Thursday, the Waukesha Parade attacked suspect Darrel Brooks delivered his opening statement. He acknowledged that people died at the Christmas parade last year, but he denied that it was planned or intentional. He says, quote, you won't hear me try to argue facts, he told the jurors. The fact is this incident is very tragic. Very tragic, he said, and that's not lost on me. Now, Mr. Brooks is obviously representing himself against 6 counts of first-degree intentional homicide, which Wisconsin's highest murder charge, and multiple other counts. The entire list of counts is 83 charges long. He chose to deliver an opening statement after the state concluded its case in chief, which the defense always has the right to do. Normally, though, the defense will make a statement up front because you want to put your theory out there for the jury to consider while the evidence is being presented by the prosecution. Since this was Mr. Brooks' first trial, he maybe didn't know that. Now, Mr. Brooks did say that there were lots of people and families healing on both sides. Obviously, 6 people died when a driver, as Brooks alleged by the prosecution, rammed a red SUV through the Waukesha Christmas parade on November 21st, and dozens were injured. Authorities said Brooks had been fleeing after abusing and harassing his ex-girlfriend, Erica Patterson, often sounding emotional and wiping his eyes during his statement. Now, Brooks claimed he had prepared no remarks, but chose instead to speak from the heart. He said that the only one side of the story had been told for roughly a year. He says there's been a lot of speculation, a lot of ridicule. Brooks fired his attorneys shortly before trial and decided to represent himself. And he is a self-professed sovereign citizen. He suggested that prosecutors couldn't bring charges against him because the state of Wisconsin is not a flesh and blood person. Well, needless to say, the judge dispensed of that legal rubbish quite quickly, and Mr. Brooks insisted on bringing him up. He even attempted to call the state itself as a first witness. Prosecutors objected to that move. The judge agreed. He also unsuccessfully attempted to persuade the judge to toss the case against him at the end of the prosecution's case in chief, which is not uncommon at all. The so-called sovereign citizen asserts that the government holds no true legal sway over them because they, not the government, are the sovereign. After failing to call the state itself to testify, Mr. Brooks called Patterson's friend, the girlfriend, Ms. Patterson, Nicholas Kirby. Sounding more like a prosecution witness and definitely not on Brooks' side, Kirby testified that Patterson had shown him Brooks' rap sheet and picture the week before the parade attack occurred. Kirby said Patterson planned to meet Mr. Brooks on November 21st, but he warned her that the meetup was a bad idea. Kirby said he was Patterson's mutual friend, Corey Runkle, and Runkle saw Patterson in Brooks' red SUV first. Kirby said he heard Patterson and asked a nearby police officer for help. Prosecutors previously called Runkle to testify. Authorities say Brooks eventually fled the scene alone in his SUV. Hopefully that'll be over soon and some justice for the family.